Hello and welcome to this morning's TIU Global Dialogue event. Today, we're going to hear from Professor Yukari Ando on the topic, Why Did She Die? Immigration Detention Policies in Japan. And I'm Chris Lamont. I am stepping in today for the moderator of today's event, Professor Thomas Blackwood, as he is unwell. I'm a professor of international relations here at Tokyo International University, and I have the pleasure to introduce our guest speaker, Professor Ando, a professor who I met actually several years ago while teaching a class on transitional justice at the Osaka School of International Public Policy. Our speaker, Professor Ando, is a guest professor at the Osaka School of International Policy at Osaka University, and her focus is on international human rights law, particularly focusing on the protection of foreigners' rights. Her recent publications include The Principle of Non-Refoulement and The Expulsion of Foreigners by Shinzan Publishing. Professor Ando, it is our pleasure to welcome you here this morning. The floor is yours.
Thank you very much, Professor Lamont. So I would like to share my PowerPoint. And today we are focusing on the why did she die? The immigration detention practice in Japan. And I introduce about what's the background and what is the immigration detention policy in Japan. And currently the immigration bill passed to the parliament, which is quite controversial from the perspective of human rights. And then we discuss about why the Wishma Sandamali died. So first of all, on March 6, 2021, a Sri Lankan woman, Miss Wishma Sandamali, died, age of 33 years old, at the Nagoya Immigration Bureau. And I would like to show the video of 5 minutes, which is quite shocking, but you can know what is the reality. So that was a quite shocking video, and I'm going to explain what happened. So immigration detention is applied for the foreigners without resident status. Resident status, we say Zairyu Shikaku in Japanese. And Immigration Control and Refugee Recognition Act is a legal background which mandatory detention policy can be applied. And there are several facilities. One of the biggest is Ushiku, located in Ibaraki Prefecture. And another is Omura Immigration Detention Center, is located in Nagasaki Prefecture. And also there are regional immigration bureaus. And about accommodation facilities, treatment of accommodation facilities, they are advertising the quite beautiful pictures under the Ministry of Justice, but the reality is not. And many people actually died in the immigration detention center. And one of that is not Miss Wishma Sandamali, but 2019, June 24th, Nigerian guy called Mr. Sani died at Omura Immigration Detention Center. And after his death, the Ministry of Justice created the Special Committee on Detention Deportation, and they published report 2020 June, and based on the report, the cabinet proposed Immigration Bill 2021 February. And 2021 March, as you saw the video, Miss Wishma Sandamali died at Nagoya Immigration Detention Nagoya Immigration Facility. And 2021 March, the joint statement on special rapporteur on the human rights of migrants, the working group of arbitrary detention, the special rapporteur on freedom of religion or belief, and special rapporteur on torture and other cruel, inhuman, degrading treatment or punishment, expressed deep concern that immigration bill is controversial of the human rights treaties. And also UNHCR, United Nations High Commissioner for Refugees, comment on amendment to the Immigration Control and Refugee Recognition Act. And UNHCR also expressed their deep concerns against principle of non-refoulement. And I will explain about what is a principle of non-refoulement, which is very, very important principle to protect the refugee and foreigners. And a lot of protests happened 2021. And finally, May 2021, the government gave up of the immigration bill. So immigration bill abolished 2021. And 2020 last year, November 13th, Human Rights Committee had a concluding observation of Japan. And during the concluding observation, they expressed deep concern about the treatment of detainees of the Immigration Detention Center. And we will look at what they said in detail later. And also this year, Special Rapporteur on the Human Rights of Migrants, the working group of arbitrary detention and the Special Rapporteur on freedom of religion or belief, again expressed deep concern against immigration bill this year. But this year, March 7th, Cabinet proposed immigration bill, and May this year, the lower House approved immigration bill. Sorry, this the special rapporteur is after the cabinet proposed immigration bill. So special rapporteur, again, they expressed their deep concern against this year's immigration bill. But unfortunately, the lower house approved immigration bill. And Human Rights Committee concluded observation last year. The paragraph 32 is very important. The committee welcomes the state party's willingness to consider measures to avoid long-term detention. It remains concerned, however, as alarming report of suffering due to poor health condition in immigration detention facilities. That is, access to healthcare is very, very important human rights. However, the most of the detainees complain against access to the healthcare. And also Karihomensha, which is now becomes the English term. Those who can have the provisional release, they cannot really sustain their lives because they do not allow to work and they cannot access to the health insurance. So that is a quite big concern from the perspective of human rights. And also, they recommend access to adequate medical assistance and also provide support necessary to immigrants for the provisional release, which is a Karihomensha, and provide alternative to detention. So alternative detention is very important concept, not detain in the immigration detention center. Instead, they can leave the community at home, but alternative detention is not really applied in Japan. Very limited person can allow to alternative to detention. And that is very, very important. Maximum period of immigration detention is not applied under the law. And they recommend to introduce a maximum period of immigration detention since long time, but yet not applied. And also, the examination by the court is not applied in Japan. And immigration bill is proposed by Immigration Service Agency. The basic idea behind the revision is ensure that those who should be protected are protected. Then foreigners whose stay is not permitted should be deported as soon as possible. And even until their deportation, they shouldn't be unnecessarily detained. And if they are detained, they should be treated in an appropriate manner. So that is a really beautiful word, why the Japanese immigration bill is proposed. But in reality, I do not really see this theory is applied for the immigration bill. And main point, what is changed, this is a current Immigration Act, and this part is the immigration bill. And there are three important changes. One is the exception of suspension clause. So during the refugee status determination, refugee claimant is not deported in current Immigration Act. However, the proposed immigration bill already passed the parliament, and within 1 year, they are going to enter into force. So even the refugee claimant can be deported if they apply more than twice. And also somebody who committed crime and delivered 3 years of they can be deported even the first time the application of the refugee. And complementary protection, which is good to create, because now we do not have any complementary protection, but persecution is main element. So I will explain later with more detail about this. And criminalization is the creating. If somebody do not deport, they can be penalized and put in the prison. But after serving the prison, they can be go to the immigration detention. That means those who do not deport, they go to prison and immigration detention center. And this is a comparative table of the UK, USA, Canada, and Japan current act and immigration bill. And refugee recognition rate is very problematic in Japan. To compare UK, like 65, 32% USA, and Canada is 62 to that 21. And actually 2020, already 70% UK and Canada. And Japan is less than 2%. So that is the background of refugee recognition rate, which is very, very difficult to be recognized refugee in Japan. And if the refugee is not recognized properly, they cannot really deport it more than twice. And max length of immigration detention is another problems. If UK or USA, they do not have that provision, but in practice, they can have the max of the detention. And Canada also, they have no provision, but detention is subject to regular reviews by the IRB, Immigration Refugee Board, which is an independent body. And the immigration bill is proposed 3 months of regular reviews, but not independent body by Immigration Service Agency. So that is a quite big concern because of the Immigration Service Agency cannot be independent body. And that is and also suspension clause is very important for those who apply the refugee status in Japan. And the current Immigration Act cannot deport during the refugee status determination, but immigration bill allowed to deport those who are applying the refugee status. And this is the complementary protection, which is introduced for the immigration bill. And those who are not refugee convention reasons, they can be protected under the complementary protection. But the proposed immigration bill, they need have the persecution. But if you look at the complementary protection for the international standards, they do not require the persecution. If you are victim of indiscriminate violence, or you are victim of inhuman treatment or torture, you are protected by the complementary protection, but the persecution is not necessary. And the principle of non-refoulement is very, very important concept and important principle of under international human rights law. And the current immigration bill also has the important provision of the principle of non-refoulement, and persons subject to deportation shall be deported to the country of their nationality or citizenship. The following countries shall not be included: the Refugee Convention, which is very important provision, and Convention Against Torture. So if you face to the torture, the Japan cannot deport those people. And also, if somebody is faced of the enforced disappearance, the Japan cannot deport. And why the principle of non-refoulement is very important, I would like to explain two recent refugee cases. One is a LGBTIQ case, Osaka District Court, 15th March this year. She was refused administrative procedure. She claimed LGBT and she cannot go back to the Uganda. And she is applied for the refugee status, but the administrative procedure, she cannot succeed it. But finally, Osaka District Court delivered discriminatory attitude towards homosexual is strong in Uganda and remains within state institutions such as the police force. When she returns home, she may be arbitrarily detained and assaulted because she is LGBTIQ. And she was recognized refugee and she can stay in Japan. And another case is a Turkish court, Sapporo High Court, 20th May last year. In Japan, especially the Saitama Prefecture, 2,000 or 3,000 Turkish court lives, and most of them applied for refugee status, but they couldn't succeed it. And last year, only one Turkish court recognized as refugee. So that is very crucial, because if you look at other G7 countries, Turkish court is recognized refugee, but only one Turkish court is recognized in Japan. So under the administrative procedure, he was refused as a refugee, and he challenged before the court, and he couldn't succeed Sapporo Regional Court, but Sapporo High Court delivered finally. He was tortured by the army for providing food to members of Kurdish independence organization in Turkey, and there are objective circumstances for fear of being persecuted. And finally, he was recognized as a refugee. But imagine if he couldn't recognize as the refugee, he might deported to the Turkey and torture, and he might die. So again, I would like to discuss with why Miss Wishma Sandamali died because of poor access to health condition, and mandatory detention policy is applied in Japan, and there is no exercise to be judged it's adequate detention or not. So I would like to have the question from you. Maybe we can discuss more about what is detention in Japan.
Thank you so much, Professor Ando, for that very detailed exploration of the new immigration and refugee control law and Japan's immigration detention policies. I know here in the audience, we probably do have some questions from our students. So I think if anybody has a question, you can raise your hand about the subject of this talk. Why did Miss Wishima die? I think there. Yes. Okay. So we have one. Please introduce yourself.
So yes, my name is Evan. I'm a second year IR student at TIU. I would like to ask, which kinds of refugees does Japan actually accept? Like what is considered acceptable refugee under the Japanese immigration laws?
Professor Ando, did you hear Evan's question? He asked, what is a acceptable kind of definition for refugee under Japanese law, given that the acceptance rate is so much lower than the other countries that you mentioned?
Okay, thank you very much for the questions. Actually, the interpretation of being persecuted is very, very strict in Japan, because persecution is one of the elements to be recognized as a refugee. And the Refugee Convention doesn't say anything about definition of persecution. And being persecuted is interpreted the narrow way in Japan. For example, one of the example which I show you, the LGBTIQ refugee, under the administrative procedure, she is not recognized refugee because LGBT is not refugee from the perspective of administration in Japan, which is quite wrong from the perspective of international standard. Because a particular social group, a member of particular social group, a lot of people recognize as a refugee because of gay. If you are gay or if you are lesbian, you are persecuted in Uganda. And recently, Ugandan law decided to be, of course, criminalized and also prosecuted due to the lesbian or gay. So that is one of the examples why the interpretation of being persecuted is very, very narrow way in Japan. And also, I can argue the professional development training is not adequate in Japan, because if you decide adequately, you need to have a lot of professional training. Country of origin information is one of the very important, and the decision maker need to know what is happening the country of origin. And if you do not know the country of origin information, you cannot really decide the adequate decision. But you know, in Japan, most of the decision makers are not very good at language. So we do have a lot of language barrier because of country of origin information is existing not in Japanese, mostly English, French, or other minor languages. So as a decision maker of Japan, they have very high language barriers. And in order to have the adequate information, we need to put more effort to correct the country of origin information. But unfortunately, the institution is not really put a lot of effort to do that.
That's very interesting, Professor Ando. If I may just follow up on that question, where does country of origin information come from in Japan? In a lot of places, you have expert witnesses who can be academics who would contribute reports to these processes. what's the equivalent process here in Japan?
Thank you very much. That's very important. Actually, the Ministry of Justice hire 5 personnel to correct the country of origin information, but 5 people is not adequate. So that is one of the challenges. Maybe we can collaborate with the university or some institution, independent institution, to have such kind of tasks.
You. Are there other questions from the audience here? Yes, so please introduce yourself.
My name is Shari, and I'm a third-year student here at TIU. And my question is, did the Sri Lankan government intervene in any way to assist with Sandamali's case? And did they put pressure on the immigration agencies for her release?
Did you hear the question, Professor Ando?
No, sorry, I cannot hear.
But did you want to? Sorry again.
Did the Sri Lankan government intervene in any way to assist with Sandamali's case? And did they put pressure on the immigration agencies for her release?
So did the Sri Lankan government? So Professor Ando, I believe the question is asking, did the Sri Lankan government put any pressure on Japanese authorities?
About the death of the Miss Wishma Sandamali.
Yes.
I do not think the diplomatic pressure from the Sri Lanka side, they are quite silent. But the journalists, media of Sri Lanka put a lot of broadcasting about her death. So that is quite important to look at why the diplomatic relation actually the Sri Lanka side, they do not put a lot of pressure on Japanese side. So from the perspective of the political science, probably that is very important to expand why that it doesn't really work.
Right, and we do have students from Sri Lanka who are here today. I guess was that covered a lot in the media in?
But like Professor Ando said, it was really silent when it came to the government and releasing statements about it. And I think it's just mainly private lawyers that are supporting the family, and the government is just silent. There's always the families of the girl who pressured the Japanese government, but not the Sri Lankan. Yeah.
So families, the media, kind of private lawyers, but not at an official level, right? And of course, for kind of political scientists and students of international relations, there's quite an asymmetric relationship, of course, between the two states in many respects that could account in part for that. Are there other questions for our speaker? Oh, sorry. Yes, go ahead. Yes.
So,
So if you can try to speak up.
Why does the Japanese government need to keep these refugees inside the immigration bureaus for a really long time when I don't really see any benefits of keeping them for such a long time for the Japanese government?
So the question is, why does the Japanese government keep people in detention for kind of lengthy periods of time? So people who don't have legal status, and you're saying you don't really see the benefit of keeping people in detention for extended periods of time.
Thank you very much for the question. That is very, very important question. Why Japanese government would like to keep such a long detention? Because the longest one is more than 7 years. Can you imagine 7 years in the immigration detention center is really crucial, and actually more crucial than prisoners, because prisoners, do know how long they are going to in prison, but the detainee does not know forever. So that is very, very crucial. And that's why we cannot really know why the Japanese government would like to detain. And the final objective is deportation. If they are the detainee going back to their country, they cannot detain. But there are so many reasons cannot go back to their country. One of the reasons is, of course, the refugee climate. They cannot go back to their country, even they want to, because they are persecuted in their country of origin. And another reason is because of family. Somebody who married with Japanese and divorced, their children is in Japan. So father or mother would like to stay with their own child. That this is why they cannot go back to their country, even they have the irregular situation. They do not have the regular residence status, but they would like to stay with their children or family members. And so those people who cannot go back to their country and they are detained for long, long time.
Are there other questions? Yes, we have another question here. Just one second. Let me.
Thank you so much, Professor, and for your presentation. I have questions about Ms. Wishma's case. Why was Ms. Wishma declined medical access? While I understand that she is held in custody for overstaying her visa, I don't think that is a good reason for her to be declined basic human rights. Is there a procedure that detainees needs to go through in order to receive medical treatment? Since in the video, we can see the staff saying, I need to ask my boss, I don't have the power. So, well, what in that case, then, is there anything their boss can do in order to?
Professor Ando, did you hear that question? So the question was asking about the procedure, kind of what procedures exist to ensure people can get medical care. And Tian mentioned that in the video, she noticed that the detention guards were suggesting that they needed permission from their boss to be able to provide medical care. So what's the criteria for the provision of this care?
Actually, that is a black act. It's a very gray area, which cannot really know from the outside. Of course, there is a rule the treatment of detainees, but that rule is not very applied in reality because liberty of the people is very important, basic human rights, and detainee need to be looked after by the guardian. But the guardian does not have any decision, as you mentioned. They ask the boss, always they need the permission what to do. And that is very crucial for the detainees. Access to the medical care is one of the most important basic human rights, which is not ensured the Immigration Detention Center. So we need to really make clear what is the procedure and guaranteed by the law clearly. However, the immigration bill does not say anything about that point.
Mm-hmm. And I think to follow up on this kind of question about medical care, but also prolonged detention, what are the circumstances that account for somebody being in detention for a period like 7 or so years? It suggests that there is a roadblock to deportation, which would suggest perhaps that the inability to return is in fact genuine. What happens in these situations when somebody cannot be removed from the country but also is in detention?
Thank you for the following questions. there are two kinds of detention under the Immigration Act in Japan. One is if you have the order of the detention, you can you detain for the max of the 60 days. But if your deportation order is issued, under the law, you can the government can detain forever until the deportation happened. And there are another system which is provisional release. If you apply for the provisional release, you can go out from the immigration detention center, which is karihomen sha, but you cannot have any access to their social security, and you are not permitted to the work. So that means you living is basically deprived, and you don't have the health insurance. And if you go to the hospital, you need to pay more than 100% usually, because public hospital asked 300% of the treatment fee. So that is the system which even you get out from the detention center, your life is very, very hard.
And one of the other things that you mentioned in your talk was this new limit that you could only apply for refugee status recognition now twice, I believe. And in the past, you could apply kind of for an unlimited, I guess, theoretically number of times, combined with kind of the statistic of only 1.95% of applicants receiving a kind of the refugee claim or having the refugee claim granted. In the past, did people have to apply many different times to get their refugee status recognized, or was this something that is this something that you can see kind of reducing that 1.9% and 1.95 and making it go lower over time if a lot of the recognitions are the result of multiple applications?
Actually, I mentioned about the 2% of the 2020, but the past years, less than 1% are recognized refugee, which is very, very strict. And most of people need to apply for multiple times because they are not recognized. And one of the example is a Turkish code. I mentioned only one Turkish code is recognized as a refugee last year, but till then, none of them are recognized as a refugee, which is quite controversial. Because if you look at the G7 countries, the Turkish code are recognized as a refugee easily. And also the Rohingya Myanmar. Rohingya, there are 200, 300 Rohingya living in Japan, in Tokyo and Gunma Prefecture. They are not recognized as refugee in Japan. Some of them are recognized, but a lot of them are not recognized. But if you go to the G7 countries, if you are real Rohingya, you are recognized as refugee, mostly automatically. So that is a quite crucial example why Japanese recognition rate is very, very difficult.
Oh, and we have another question from the audience. Dean Akitoshi Miyashita of the E-Track program.
Professor Ando, thank you so much for your presentation. I learned so many things from your presentation, and you mentioned about the strict interpretation of persecution in Japan, or the Japanese government hiring only 5 people to investigate the information about the origin of those immigrants. Certainly, we have a lot of programs, and those programs piled up in causing the death of Ms. Wishma Sandamali. What do you think is the real cause for these? Do you think that there is a program in the organizational, structure, like the Justice Department, the Ministry of Justice, incapacity to handle these issues, their inexperience? Or do you think it's a deeper, like Japanese society, people not willing to accept foreign immigrants to our own community? Or is it more of a political, meaning that the conservative elements in the ruling Liberal Democratic Party is trying to block the foreign immigrants? What do you think are the root cause for those programs that we have been discussing? And given the increasing international and domestic pressure on Japanese immigration policy, do you think that the Japanese immigration policy will change in the future, or do you think that the low rate of acceptance will remain the same? What do you think about this?
So thank you very much for the question. Professor Ando, were you able to hear that?
Partly I heard, but partly not.
Yeah, sorry, we cut out there. So oh, just a second. Let me get the question was about the root causes of the problems that we have described here. So the first was, is it a administrative managerial problem, a bureaucratic problem, where kind of the Ministry of Justice needs to fix kind of its kind of internal organization and procedures, or make it kind of improve that? Or is it a social societal problem where the Japanese people more broadly are reluctant to accept foreigners in Japan? Or is this kind of a political problem with the LDP accounting for this, what we have just witnessed, or what you've talked about here, these types of practices that resulted in kind of the death of Wishma Sandamali?
Thank you very much for the questions. Actually, there's so many reasons why that happens in Japanese society, and one of the reason is, of course, the bureaucratic problems. The Ministry of Justice had a lot of authority, especially the Immigration Service Agency, and they do not have the legal control into that. So that is one of the challenges. We need to change the system itself. And also the ordinary Japanese are not really welcoming those who violate the rule. And we call the illegal migrant. And the term illegal migrant is not adequate from the perspective of international standard. And actually the US administration changed a couple of years ago. They do not call anymore illegal migrant, but irregular migrant or undocumented migrant. Because the term illegal provides really bad image. And illegal is not adequate terminology of the undocumented or irregular migrants.
네,
So
맞아요.
the political, from the political perspective, maybe we need to change the terminology first and to change the people's mind.
Thank you for that very kind of in-depth answer into a very complex question. I think we have time perhaps maybe for just one more question this morning for Professor Ando, or maybe two. The two hands have gone up, so maybe we have time for two questions. So again, Shady?
How important is it for the new bill to demand transparency from these immigration agencies? As I understand, there's a lot of gray area when it comes to their inner operations. And do you think if transparency is provided to the public, would the treatment towards detainees change?
Okay, so to what extent does this new bill demand transparency from immigration detention agencies? And to what extent do you believe if there was transparency that would improve the treatment of detainees?
Transparency is nothing so far. Yeah, to be honest, that is very, very black area. And that's why as the recommendation of the Human Rights Committee, the legal decision should be interrupted. But the Immigration Act doesn't really change that direction. So we need to talk more about what should be changed, especially the transparency is very, very important.
Right. And we have now one more question from Evan again. Go ahead.
Yeah, Professor, I would like to ask, is there a very specific reason why the Japanese government is very reluctant to accept Turkish Kurds in particular compared to other G7 countries, considering that the government accepted more than 2,000 Ukrainian refugees, but why did it take so long to just accept one Kurdish?
Okay, so what accounts for Japan's resistance to recognize Turkish Kurdish refugees, considering that, as you mentioned in the presentation, Japan has only accepted one, and Evan contrasted that with the kind of Ukrainian, I believe they're evacuees who have been brought to Japan.
Thank you very much.
Over 2,000.
Actually, the Ukrainian evacuee accepted from the top down. The Prime Minister Kishida decided very early stage, we do accept Ukraine. So that is actually the political decision, but not recognized as a refugee. And for the refugee, it's a different procedure. Of course, we need to look at the definition of a refugee convention. And as I explained, the interpretation is very, very narrow way. And one of the problem is that decision maker of Japan do not know the human rights treaties. So maybe we need to explore more educational system to look at what is a human right. And hopefully, maybe next generation can change the concept of human rights. It's very different from what we do in Japan.
Well, thank you so much for that, Professor Ando. And on that kind of note, on kind of highlighting the need for human rights education in Japan going forward and the potential for change offered by newer kind of upcoming generations, we will unfortunately have to close today's event. Professor Ando, thank you so much for contributing.
Thank you very much.
It was a great pleasure to see you again and to welcome you for this webinar. And thank you so much to the audience as well for attending today. So with that, I will close the webinar. So thank you so much, everybody.